the Arbitration Agreement. It has basically three portions. One is a written agreement relating to present disputes, meaning thereby that there should be a pre-existing dispute between the parties. There is a dispute, there is a difference, so the differences are to be resolved through arbitration agreement. And for that purpose, the arbitrator is appointed. And beforehand, he at the term of reference are settled. And the arbitrator is told that these are the differences between the parties. So the first part is that agreement should be writing in written form to submit present differences, naming the arbitrator. And the second part is regarding the future differences. What are the future differences? There is a contract agreement between A and B. They insert a clause in that agreement, in that contract agreement, that all disputes shall be decided through arbitration. So they may give the name of the arbitrator in that clause, that the dispute should be resolved through arbitration, appointing Mr. Fala and Fala as arbitrator. And the third part is that the arbitrator is not named. Suppose there is a contract between two parties. There is a clause, arbitration clause in it, which reads, all disputes arising from the contract shall be decided by an arbitrator. There is no name of the arbitrator. In one situation there is a name of the arbitrator. In the second situation there is no name of the arbitrator. If the arbitrator is named therein, then there is no dispute of appointment of arbitrator. There may be any other dispute, but not about the name of the arbitrator. And the second situation is that the arbitrator is not named. In the first situation, the arbitrator is named, but one party says that I am not going to refer the matter to arbitration. The other party says that it should be referred to the arbitrator. Then the matter will be decided by the court. This is called appointment of arbitrator with the intervention of the court. Arbitration with the intervention of the court. But if they themselves agree, well and good. But if they don't agree, then the matter will be referred for intervention of the court. In the second position, where the arbiter is not named, again the matter will be decided through intervention of the court, and the arbitrator shall be appointed by the court itself. So this is what the arbitration agreement means. It should be in the written form. It should submit present differences, future differences. Arbitrator should be named, or arbitrator should not be named. If he is not named, it does not mean that there is no arbitration agreement. Arbitration agreement does exist even if the arbitrator is not named therein. So if arbitration agreement is there, then it shows certain terms and conditions. But there are certain conditions, there are certain matters which are not included in the contract. So there are implied conditions. Section 3 of the Arbitration Act says that there are implied conditions. An arbitration agreement, unless a different intention is expressed therein, shall be deemed to include the provisions set out with the first schedule, insofar as they are applicable to the reference. So there is a schedule in the Arbitration Act which provides certain conditions. These conditions are implied in the agreement. If the agreement is silent on these conditions, even then it shall be deemed that these conditions are part of the arbitration agreement. Now we have to see what those conditions are. These are 8 in number. Number 1 is, unless otherwise expressly provided, the reference shall be to a sole arbitrator. Suppose there is a contract agreement. It has a arbitration clause. In the arbitration clause, we find that the arbitrator is not named. We find that the number of arbitrators is not named. The words show that all disputes shall be referred for arbitration. But who will be the arbitrator? Not shown. How many arbitrators shall be there? Not shown. So in this situation, paragraph 1 says the reference shall be to a sole arbitrator. It shall be deemed that this clause shows that there shall be only sole arbitrator. So the matter shall be referred to a sole arbitrator. But if there are more than one arbitrators, if they are in even number, then what happens? There is a chance of difference of opinion between the arbitrators. If there are 2 arbitrators, we may presume that one will say one thing, the other will say other thing. So there will be a difference. So how to resolve it? The agreement is silent on the point. There is nothing in the reference agreement. The parties have appointed 2 arbitrators without giving anything in case they do not agree. If they do not agree, then what will happen? So for this purpose, paragraph 2 of the first schedule says, if the reference is to an even number of arbitrators, the arbitrator shall appoint an umpire not later than 1 month from the latest date of their respective appointments. Both will appoint an umpire. The umpire shall exercise the powers if there is a difference of opinion between the two. So it is the duty, rather obligatory, on the 2 arbitrators to appoint an umpire within 1 month from the latest date of their respective appointments. So appointment umpire is for the purpose of resolving the dispute between the 2 arbitrators. If they are in even number and they disagree, then the umpire will perform his duty. So the next point is, the parties have appointed arbitrator, and the arbitrators have entered upon reference, and those do not decide the matter for so many years. Arbitration agreement is silent on the point. It does not give the time to the arbitrators, then what happens? Can they be given a time without any limit? The answer is no. Paragraph 3 of the schedule of the Arbitration Act provides certain limits. The arbitrator shall make their award within 4 months after entering on the reference or after having been called upon to act by notice in writing from any party to the arbitration agreement or within such extended time as the court may allow. So this paragraph has 3 portions. Number 1 is that he has entered on the reference 4 months from the date of entering on the reference. Second part is after having called upon through notice within 4 months from that, or if the 4 months have expired, he has entered on reference, or he has been called upon. Even then 4 months have expired, but the parties intend that they should decide the matter. Then the court has the power to extend the time. The arbitrator himself, or one of the parties, or both parties, shall move the court to extend the time. And if the time is extended, then the arbitrator shall pronounce his award within that time. So there is a limit of time for the arbitration proceedings. If the arbitrators have allowed the time to expire without making an award, or have delivered to any party to the Arbitration Agreement or to the umpire a notice in writing stating that they cannot agree, the umpire shall forthwith enter on the reference in lieu of the arbitrator. The time prescribed for the pronouncement of award to the arbitrators, the time has expired. They have allowed their time to expire. They did not make the award and did not deliver it to any party. Then they will convey the matter to the umpire that they do not concur, they have failed. Then the umpire shall enter on the reference. He shall be appointed by the arbitrators if they are even in number, and if the arbitrators fail to pronounce the award within the period, or they do not agree on account of their own differences, on their logic, their own reasons, they do not make the award, then they will call upon the umpire to pronounce the award. Then the umpire shall forthwith enter on the reference in lieu of the arbitrators. Then the umpire will make the award. Paragraph 6. The parties to the reference and all persons claiming under them shall, subject to the provision of any law for the time being in force, submit to be examined by the arbitrators or umpire on oath or affirmation in relation to the matters indifference and shall subject to the aforesaid produce before the arbitrators or umpire all books, deeds, papers, accounts, writing and documents within their possession or power respectively, which may be required or called for, and do all other things which during the proceedings on the reference the arbitrators or umpire may require. So this paragraph 6 is a procedure which is to be adopted by the arbitrators, and the parties are under an obligation to cooperate with the arbitrators in recording the statements, in examining the record, in inspecting the books, deeds, papers, accounts and writings, etc. So this is the procedure which is to be adopted by the arbitrator. An arbitrator, so when the arbitrator makes the award, what is its effect? Paragraph 7 says, the award shall be final and binding on the parties and persons claiming under them respectively. On the parties and on all those persons who are claiming under them, the award shall be binding. Although arbitrators are not the court, they do not fall within the definition of the court. Arbitrators are only arbitrators, but their award is binding on them. So far as the cost of reference is concerned, it may be levied by the arbitrators. So these are the 8 paragraphs which are implied conditions of the arbitration agreement. If there is an arbitration agreement and it gives the detail of the terms and conditions of reference, but there are certain conditions which are not included in it, then these implied conditions shall be part and parcel of that contract, and the parties shall be bound as if they themselves have entered into these conditions. In a society, a man has relations with other men. A man has relations with a group or groups. And in a society, a group has relations with other groups. Sometimes in these relations, confrontation crops up. Sometimes differences occur and the disputes arise. So in this situation, a social contract provides a methodology of judicial system. In a judicial system, a court declares the rights, enforces the rights, and protects the rights, and brings the wrongdoers to justice. But a layman, an ordinary man, a poor man, cannot bear the brunt of protracted litigation. So in order to facilitate him, the best method which has been propounded so far is the arbitration. Arbitration is a methodology which enables the people to decide their matters out of court. For the purpose, an arbitration agreement may be entered into. In order to appoint an arbitrator, there is no need of any official intervention. The parties may themselves enter into an arbitration agreement. So how it happens? Section 2A of the Arbitration Act says, arbitration agreement means a written agreement to submit present or future differences to arbitration, whether an arbitrator is named or not. So this is arbitration agreement. It is a start of arbitration proceedings. So when we go through this section, we find that arbitration agreement is in written form. So this agreement has also been defined in PLD 1988, Peshawar, page 133. Arbitration agreement, meaning, scope and import of. Arbitration agreement means written agreement to submit present or future differences to arbitrators, even if no arbitrator was named therein. Arbitration Act was neither reduced into writing, nor there was anything to show nature of dispute, which was agreed to be referred to arbitrators, and terms of reference were also not given in the award placed on file. Trial court, ignoring all such fundamental requisites for assuming jurisdiction, proceeded on assumption and conjectures. Assumption of jurisdiction by trial court was in derogation to requirement of law. This authority explicitly reveals that an agreement means a written agreement. There can be no oral agreement or reference. So arbitration agreement must be in writing. Now the question is whether the arbitration agreement can be entered into without making signatures on the document. So in this regard, the first thing which is necessary for the purpose is that there should be a dispute which may be reduced into writing. There must be a dispute. Then what is a dispute? The question is as to what the dispute is. The answer to this question is given in 204 CLC page 44. Word dispute. A dispute implies an assertion of a right by one party and repudiation thereof by another party. A failure to pay a claim constitutes a matter of difference between the parties to a submission. Where lesser claims outstanding amount of lease, while lessee repudiates, it is a dispute arising out of contract containing arbitration clause. So there should be a dispute within the meaning of this authoritative pronouncement. Now the question is, who can be an arbitrator? What are the qualifications of an arbitrator? What are the characteristics of an arbitrator? Who can be an arbitrator? The answer to this question, we find it in 2003 YLR 1109. Arbitrator Corporate body is a legal person and cannot act as arbitrator, as its constitution can be changed at any time. Only a natural person can act as arbitrator, so as to hear parties and give decision, award after applying mind to same. Meaning thereby that there can be no arbitration by a company. There can be no arbitrator which is a firm. It is only an individual person who can be appointed as an arbitrator. A man who is of age of majority and of sound mind may be appointed as an arbitrator. There is no other condition attached to it. Now we are discussing the arbitration agreement, that it should be in writing. Writing does not mean signed. It does not mean that it should be signed. Where the parties enter into a reference agreement, reduce it into writing, but do not make their signatures thereon, the award is valid. The arbitration agreement is a valid document. It need not be signed. There are two authorities on the point. 2002 SCMR, page 1903 and 1987 CLC, page 83. Reference to arbitration. Requirement. For referring matter to arbitration, signatures of parties on agreement not necessary. And again, signature of parties on agreement not necessary. Such agreement, however, was required to be in writing. So the only requirement is that it should be written with the consent of the parties. Such agreement, however, was required to be in writing. Even if such agreement was not signed, parties would be bound thereby, and matter could be validly referred to arbitration. This objection is not valid, that it is not signed, it is not attested by witnesses, it does not carry weight. These objections are not available because the only requirement is that arbitration agreement should be in writing. Because the definition itself says arbitration agreement means a written agreement. It does not require the signature of the parties, so it need not be signed. So what is the effect if there is no written agreement? The authority is PLD 89, PLD 1989, Peshawar 166. Arbitration agreement, submission to arbitration, essentials. Essential ingredient to a valid submission to arbitration is the agreement to arbitrate should be contained in a written document agreed to by parties to such submission or by their agents duly authorized in their behalf. Arbitration award without any arbitration agreement in writing between the parties would carry no weight and would have to be ignored altogether. So the only thing which is a requirement of law is for the arbitration agreement is that it should be in writing and it should submit the present or future differences to arbitration. What is the requirement of the Constitution? 1987 CLC, page 2509. There is no legal requirement that in order to constitute an arbitration agreement, there should be a formal agreement executed by the party. But what is required is that the agreement should be in writing, which may be in the form of a letter or other document, provided it depicts the voluntary agreement between the parties to resolve present or future differences. I repeat, there is no legal requirement that in order to constitute an arbitration agreement, there should be a formal agreement executed by the parties. But what is required is that the agreement should be in writing, which may be in the form of a letter or other document, provided it depicts the voluntary agreement between the parties to resolve present or future differences through arbitration.